Hello, I'm Matthew Geiger with Cape Fear Family Law, and today I'm here to talk with you about evidence that you'll need to defend yourself in a child support contempt proceeding. If you find yourself falling behind on child support and you miss a couple of months of payments, it's likely that you will be issued and served with an order to show cause. An order to show cause is issued and requires you to make an appearance before the court and show why your non-compliance was not willful. To be held in contempt for falling behind on your child support, your non-compliance has to be deemed willful. When determining if non-compliance is willful, the court looks and tries to make a determination of whether or not you had the means to support obligation and just decided not to do so. Or if you had a job and you were making good money which allowed you to make your child support obligations, were you terminated with cause requiring you to be put in the position you're currently in? The types of evidence that you'll need to bring to court to defend yourself on this show cause action can vary on a case-by-case basis, but today I'm going to give you a couple of examples. For instance, right now, due to the current COVID-19 pandemic, many people are finding themselves laid off, terminated from their jobs due to no fault of their own. Certainly that is not a willful non-compliance. What you need to do if you find yourself in that situation is to make sure to go ahead and file a motion to modify your support obligation immediately. Then you need to prepare to get a letter from your employer stating that your termination was due to the COVID-19 situation, and it was not a willful termination, it was simply out of your hands. That way, when you go to the court, you can show them that your non-compliance was not willful and that you've taken the steps to put yourself in a position to get your child support obligation to where it should be based off of your new financial standing. Additionally, if you find yourself laid off, it's helpful to bring to court proof that you've been looking for new employment. This could be as simple as providing applications that have been submitted on your popular job sites such as Indeed.com or Monster.com. If you've had personal interviews with employers, see if you can't get a letter or something showing that you did in fact have that interview. Again, it goes to showing that you're not willfully non-compliant. You're taking the steps to put yourself in a position to meet your child support obligations. Another situation could be if you find yourself out of work due to disability or being injured and trying to qualify for disability. If you find yourself in this situation, you've been issued an order to show cause, it's important to be prepared when you come to court to have letters and documentation from your medical care provider stating your diagnosis and their opinion that you should not be working or that you are unable to work. You should also try and go ahead and apply for disability and be able to show the court that you've taken those steps and that the reason you're out of work is due to a valid reason. It's not you just saying, I don't want to work. You have the proof that's going to back up your claims in court. That's going to go a lot further than you just coming into court stating that you have an injury and you're unable to work. Having this supplementary evidence goes a million miles in showing the court that this non-compliance was indeed not willful. Again, these are just some instances in which you might find yourself when you're being issued with an order to show cause. There could be a unique situation to you that I haven't mentioned today. If so, please let us know in the comments and we'll be happy to address it. As always, like, subscribe, and let us know in the comments what you think. Thanks.